In California, child support is paid until a child is 18, or if still a full-time high school student, 19 or graduation, whichever occurs first. Also, if a child becomes emancipated or marries, the child support ceases. Family Code Section 3910 provides for the special situation in which a child is so disabled as to be unable to become self-supporting. In this situation, child support may be paid even when the child becomes an adult. If California is enforcing a child support order from another state, that state's laws will control the length of time support is paid, and may be longer than California. The parties may agree to pay support for a longer period of time. This agreement is enforceable, the same as any other child support order. The parties may not agree to waive child support if the children are under the age of 18. Most of the time, the incomes of the parties can be determined by looking at paycheck stubs or W-2 forms. If a party is self-employed, however, it may be more difficult to determine that party's income. The starting place to calculate the income of a self-employed person is the Schedule C, or profit and loss statement. Some deductions allowed by the IRS are not allowed as deductions for the purposes of child support, such as depreciation on real property or vehicle expense if used for both business and personal use. These deductions are then added back into the net income. In self-employment situations, the court can compare a party's claimed net income with the claimed living expenses. If the expenses far exceed the income, the court may determine that the party has more income than is being claimed. In some circumstances, the court can impute income to a party who is unemployed or underemployed. Family Code Section 4058 allows the court to consider a parent's earning capacity instead of actual income in certain situations. The party requesting the court to impute income based on a parent's earning capacity has the burden to prove to the court that the other party can earn more income than they are currently earning. The imputed income must be reasonably related to the party's actual ability, and there must be employment available. For example, if father has never earned more than $10 per hour working as a laborer, it would not be realistic to expect him to obtain a job earning $40 per hour as a supervisor. Incarcerated parents cannot usually be ordered to pay child support, as they do not have an opportunity to earn, even though they would have an ability to earn if they were not in jail or prison. Under Family Code Section 4058, the court may consider the earning capacity of a parent's investment assets when setting support. There are many cases which address the issue of using assets as income for support. Therefore, you should speak with an attorney if you believe the other party has significant investment assets which should be used for support. If income-producing assets are being underutilized, the court can assign a higher rate of return. However, the rate of return must be reasonable. The equity in a family residence is not considered available for support. Employer-provided benefits can be included as additional income in the calculation of child support if the benefit reduces expenses a party would normally have. The rationale behind this is that a party would have to have enough income to pay for the benefit being received if the employer did not provide it free of charge as a part of compensation. Usually, these benefits are considered non-taxable income, as the party would have to have, in hand, cash to pay for the benefit. If an employer provides a benefit to an employee as a part of the employee's compensation, the value of the benefit can be included as non-taxable income. For example, if a party is the manager of an apartment building and receives, as part of his compensation, an apartment free of charge, the rental value of this apartment may be considered as income. If an employer provides cash to a party to pay for an expense, this can also be included as income if it is part of the employee's compensation. A common example is an allotment paid by the military for a service member's housing expenses, known as BAH. This payment is included in the child support calculation. A court case of some type must be opened in order for the court to issue an order for child support. In any divorce or legal separation in which there are minor children, the court will make orders for child support. This order can be by guideline or by agreement and will be part of the final judgment of divorce or legal separation. If the parents are not married, either the mother or father can open a petition to establish a parental relationship. The issue of parentage, custody, and support will be decided in this type of case. Either parent may request the Department of Child Support Services to open a case for child support. If the custodial parent is receiving public assistance, DCSS will open a case to obtain reimbursement for the assistance received. Once a case is opened, either party may file a motion called an order to show cause to obtain child support. Temporary orders are filed either at or after the case is opened, but before the final judgment on all issues. Often these temporary orders are eventually added to the final judgment. Modifications of orders are also obtained by filing an order to show cause, either before or after the final judgment. Child support orders are always subject to modification until the child reaches adulthood. Income withholding orders are the easiest and most frequently used method of collecting child support if the payor does not pay directly to the other parent. Income withholding orders are commonly referred to as wage garnishments, although this is not an accurate name, as wage garnishments are generally used to collect back support or other monies owed. Income withholding orders are obtained by submitting a form, the FL 195, to the court for signature, and then submitting a signed copy to the payor's employer. The employer sends payment to the state disbursement unit, which then sends the payment directly to the payee. All child support orders obtained through the Department of Child Support Services include an income withholding order. If the case is just between the parties, either one of the parties can request an income withholding order, although it is not mandatory. A writ of execution is a process to collect money owed to a party. This process can be used for any money owed by court order, not just child support. If support arrearages are owed, the party to whom the support is owed can apply for a writ of execution to collect the money owed to him or her. This writ of execution is filed and presented to the Sheriff's Department to execute against wages, bank accounts, or other sources of money. This process can be effective if the payor has some source of funds to collect from. You should seek assistance of the family law facilitator or an attorney for help in preparing the writ. An abstract of support judgment is an easily prepared document which is recorded in the recorder's office in any county where the payor has property. An abstract of support judgment can be filed even if the payor is current on support. Recording an abstract will not necessarily result in payment of any money owed, but will place a lien on any real property held by the payor. Contempt is a quasi-criminal process which can be quite involved, time-consuming, and difficult for a self-represented person to do. The purpose of contempt is to punish the person violating a court order. The person being charged with contempt is entitled to have an attorney appointed to defend him or her, just like any other person charged with a crime. The person bringing the contempt does not have the automatic right to have an attorney and has the burden to prove that the other party disobeyed a court order. If the person charged with contempt is found guilty, he or she may have to perform community service up to 120 hours for each count. For additional findings, the sentence is increased. Any party can request that the Department of Child Support Services enforce a child support order, even if they are not receiving public assistance. DCSS has the ability to do any of the enforcement procedures listed above, and DCSS has additional powers to enforce support by intercepting tax refunds, suspending driver's licenses and other licenses, placing liens on workers' compensation awards, and enforcing orders from other states. If the payor is self-employed or employed under the table, the payee should probably request the services of DCSS to enforce the child support order. This video has provided you with a brief overview of the complicated issue of child support. Child support orders vary case by case depending on the facts of each situation. If you need further assistance regarding your particular case, you may seek the services of a private attorney or the family law facilitator. Additional resources can be found on the Judicial Council website at www.courtinfo.ca.gov. This workshop was designed to provide basic information to help you help yourself if you are not represented by an attorney. It is not intended to replace in-depth legal advice specific to your situation, which can only be obtained from an attorney.